Or anyone does? Or anyone does? Hello, everyone. Welcome to Court with Krissy and Linda. We've got bad news and good news. Bad news, the defendant was arrested last night. Good news, it was in the right jurisdiction and he isn't missing his court sentencing. The guy is a dip in more ways than one. We hope you like it. Court with Krissy and Linda is now in session.
Hey, did you have enough time to go through the PSI with your attorney?
Yes, sir.
All right. Do you need any more time to do that?
No, I found some.
I'm sorry?
I found out what I need to figure out.
Okay.
Things.
Mr. Seeger, on behalf of the defendant, first, I know that you had filed a sentencing memorandum. I have a response to the sentencing memorandum, but outside of that, did you have any other corrections, additions, or deletions?
No, Your Honor.
You believe the guidelines have otherwise been accurately calculated, other than OB-19?
Correct, Your Honor.
All right. And then Mr. Ziegler, do you have any other corrections, additions, or deletions?
I do have a correction, Your Honor, on the evaluation plan, second to last line. It says sentencing guidelines have been scored at 14 to 23 months.
To 29, unless I make the change.
Correct.
The objection. So the court will make that change. Mr. Seeger, do you agree it's actually scored at 14 to 29? I know you're asking it to be 12 to 24.
Yeah, yes, Your Honor. I did allude to that in my brief.
So we'll make that change. Any other corrections, additions, or deletions? Into the people believe the guidelines are accurately scored.
I do.
So your objection, Mr. Seeger, I've had a chance to review your written objection as well as a written response. So I don't need a ton of additional oral argument, but I will allow some if you wanted to summarize any response you had in the prosecutor's response to your.
Your Honor, I would just rely on my brief.
Okay, Mr. Ziegler, on behalf of the people.
And likewise, Your Honor, I think it's a straightforward issue. I would rely on my brief.
So the question is the scoring of OB-19 and whether or not it's supported by a preponderance of the evidence. And in this case, the probation department scored OB-19 at 10 points, which suggests a finding, or that this court could find that there's a preponderance of the evidence to suggest that the defendant interfered with or attempted to interfere with the administration of justice. The court would note that in general, I think some of the objections by the defense are accurate. For example, there's no requirement that defendant is constitutionally required to take a blood draw. On the other hand, the fact that a defendant, if there was preponderance of the evidence to show that he resisted a blood draw, does not mean he could not be considered to be interference with the administration of justice. Meaning the fact that you have a right to not take a blood draw does not mean that you have a right constitutionally or otherwise to resist a blood draw. Again, that's not the factual circumstance in this case, but I think there's a clear difference in between what the argument is and the way I view the law in this case. This is a case where there are a couple of problems, in my view, at least with the response to the defendant's sentencing memorandum, and perhaps you could hear those, Mr. Ziegler. But one example is, at least my copy, and this might be a printing issue, but you had referenced the attached exhibit A, which was a police report. I don't have a copy of that, and again, it might be a printing issue. Perhaps you have it attached as an exhibit to your response. Do you have the police reports available?
I can get you a copy, Your Honor, if you have it.
Well, let me ask it first from defense counsel then. The assertion by the prosecutor is that the police reports provide additional information over and above what the PSI provides. Do you agree with that?
I don't know if I agree or disagree, but.
Well, you read the police reports, right?
I did, Your Honor.
So how could you not agree or disagree?
I mean, I guess I agree that there's additional information contained within the report that's not specifically spelled out, but I rely on the PSI. The court
I don't, unless they're supplied to me. But my question is the prosecutor accurately supplying the information from the police report?
Yes, Your Honor. I'm not disputing what you stated.
All right, and so my question better is this: if I were to review the police report, A, is there a basis upon which you could object to me reviewing the police report to expand the information that I can consider at a sentencing hearing?
I don't know if there's a basis, Your Honor. I guess my general objection would be that the Department of Corrections created a pre-sentence investigation report for which ordinarily a police report would not be attached. If the court in its wisdom believes that it can review it, I don't have any law to support that it can. And that may be similar to a preliminary examination, except for the difference would be that in a preliminary examination, those statements were made.
Well, but let's say you had an objection to a scoring guideline. I would not be able to lawfully prohibit you from bringing additional information to my consideration about whether or not a scoring objection was accurate, would I?
No, Your Honor, I can object to any scoring variable.
And you could bring up any other information to object to it, right?
Some may require an evidentiary hearing of some sort. Your Honor,
Okay, but ordinarily, I'm not going to stop you from bringing in outside information to support or refute a scoring objection.
You most likely would not. And, no.
And so under what basis would I require the prosecutor to be under a different burden? In other words, if he had additional information for the court's consideration on challenge to guidelines.
I don't particularly have one, Your Honor. I was
Okay.
just merely answering your question.
All right, well, so what I'm doing then in the context of making my ruling is I'm presuming for a couple of reasons that the information supplied by the prosecutor is accurate. I'm presuming it because I don't have any basis in my mind. I'm not aware of any reason why the prosecutor couldn't also seek to supplement PSI or the record. And then I could consider that information for scoring purposes. The second reason I'm presuming that is because defense has made clear that at least in terms of the factual assertions made by the prosecutor, they're correct. They're not made up. They're supported by the police report if I was to review it. So because of those concessions, I don't have any need to review the police report. Again, that's one part of the three-part analysis the prosecutor asks the court to engage in. Again, what I have to find is whether or not there's a preponderance of the evidence to believe that there's interference with or attempted interference with the administration of justice. And here, what the court looks at is three different potential bases. The prosecutor asked me to look at first, whether or not Terry Harper was in the vehicle. Mrs. Harper had a PPO in effect against the defendant at the time. And I don't find that as a particular basis for OB-19. I understand the prosecutor's argument that a violation of a personal protection order could itself be interference with the administration of justice. Within the context of a PPO, I agree. But I have to determine in my mind whether or not the interference with the administration of justice is in this particular case. And I don't think that particular basis has any relationship to the instant sentencing offense of OWI 3rd. Secondarily, however, the prosecutor asked me to point to the fact that during the arrest, there were suggestions by Mr. Goodman to have Ms. Harper, the rider in his vehicle, the passenger, to remove bottles from the vehicle. And I tend to agree with the prosecution that from a preponderance of the evidence standpoint, a defendant charged with operating while intoxicated, offering or suggesting to a co-defendant or passenger in his vehicle to remove bottles from a vehicle, which may support the evidence necessary to convict him of either possession of a open intox and or operating while intoxicated charge and further support or provide evidentiary support for it, is clearly an attempt to interfere with the administration of justice and the officer's investigation. And during the stop, there's also indications by the prosecution that the defendant was told to stand by the front of the patrol vehicle, and when the officers went to go open the vehicle and search over defendant's objection, he was aggressive towards the officers and quickly moved towards them. Again, that is by a preponderance of the evidence, factual circumstances which are interference with the administration of justice, or at least attempting to do so. And while I, again, agree that there's not necessarily a requirement that the defendant submit himself to a blood test result, that's not what's claimed by the prosecution in terms of the fourth allegation. The fourth allegation is that the officers, while they were housing or attempting to house a defendant in jail, required him to spit out chewing tobacco. And there's a couple of different independent reasons why that's a lawful authority. It's a lawful command. Number one, the officers have a duty to search any defendant coming into the Kalkaska or other jail to make sure that individual doesn't have contraband. Allowing a defendant to choose what he keeps in his mouth would subvert that process. It would interfere with their ability to properly do that. Secondarily, in this particular case, this was an investigation, again, circling around and concerning allegations of operating a vehicle while intoxicated. And while it might be said correctly that the defendant has no duty, no requirement under the law to take a PBT, one of the requirements for an accurate PBT is that the defendant not have anything in his mouth for 15 minutes before a PBT is offered. And so to the extent the police officer is trying to investigate an OWI offense and ask the defendant to clear his mouth of tobacco so that he can do that, defendant's obstinance and refusal to clear his mouth is also, in the court's estimation, interference with the administration of justice by allowing them to complete their investigation. Certainly, if the officers took a PBT while the defendant had some sort of tobacco or other things in his mouth, defense might claim the inadequacy of the PBT test result and that I should not even consider it. Just the same, if the defendant's offer to resist what is a lawful command to clear his mouth, again, for both of those reasons, is found by the court to be interference with the administration of justice. Again, the standard of proof is preponderance of the evidence based upon those several different items that I've just gone over. The court finds there's sufficient basis to score OB-19 at 10 points. So the objection is overruled. The proper guidelines range is 14 to 29. On behalf of the people, do you have any, you don't have any victim that wants to allocate, do you?
No, Your Honor.
On behalf of the people, please.
Your Honor, Mr. Goodman is here for an OWI third offense. It's his 25th criminal conviction. And while that is already a dubious achievement for someone who's 55 years of age, it's even more remarkable given that by my math, looking over the PSI, he spent over 22 years of his life in jail or prison for various offenses. Mr. Goodman has a history of ignoring bond conditions, ignoring PPOs, drinking to excess, and generally violating the laws of the state and the orders of the court. I can recall several reports where law enforcement were called to the residence of Mr. Goodman, and he was intoxicated, and Ms. Harper was present. Mr. Goodman was charged with another OWI earlier this year, but the witness that placed him in the driver's seat was unavailable to testify to that fact. The last time Mr. Goodman was before this court for sentencing was 3 years ago for possessing a weapon as a felon. He was given 13 to 60 months. He served 18 months, and he clearly did not learn his lesson, Your Honor, just as he has never learned his lesson after 22 years of incarceration. I would also note that of his 22 adult offenses listed in the PSI, he was on some kind of supervision, bond, probation, or parole at the time of his offense on 11 of those 22 offenses, and was unsuccessfully discharged from probation multiple times. And Your Honor, just last night, Mr. Goodman was arrested by the Kalkaska County Sheriff's Department for engaging in new offenses. Police were called for an assault and battery. They arrived. Mr. Goodman proceeded to resist the officers' attempts to arrest them. He was heavily intoxicated, and he told the officers at some point during this incident, "I'm going to prison anyway, just take me." All of that suggests to me, Your Honor, that Mr. Goodman is certainly not a candidate for probation, but that nothing will really deter him from continuing to engage in this type of behavior. He's conclusively demonstrated over many, many years that there is nothing to do with him other than to separate him from civilized society for as long as legally possible, for the protection of the public in general, for the protection of his victims in particular, and even frankly for his own protection. I ask the court to impose a prison sentence at the absolute top of the guidelines.
Would you agree if you were accurate, if your statements are accurate, if Mr. Goodman was arrested yesterday, that I need to adjust jail credit?
In the sense that there would be 1 day of credit that he's not entitled to.
Why would he not be entitled to an additional day if he was arrested?
Oh, I see what you're saying, Your Honor. Yes, he would have been in custody from last night till today.
Do you agree with that, Mr. Seeger?
I do, Your Honor.
All right. Allocution on behalf of the defense.
Your Honor, clearly the court is being fair because it's giving them credit for an additional day that I didn't even really contemplate. I was more concerned about the larger picture of things for Mr. Goodman. In any event, Your Honor, Mr. Goodman knows that he can't consume alcohol, and he certainly can't consume alcohol while he's operating a motor vehicle. He recognizes that it's a danger to him, it's a danger to the public, and he recognizes that drinking alcohol has historically been a downfall for him. Be that as it may, Your Honor, albeit I do understand that Mr. Goodman does have a prior criminal history. That prior criminal history is already contemplated by the guidelines. What may have happened yesterday has no bearing on this particular hearing whatsoever, in as much as he's entitled to a presumption of innocence. Those are merely allegations at this time. There's not even a complaint filed, although I do understand that he may be arraigned. In any event, Your Honor, I would just ask the court to fashion a sentence that's just and reasonable. Clearly, Mr. Goodman has struggled with his substance abuse problems, and there are a lot of reasons why he has substance abuse problems. As much as Terry Harper may have played a part in this, Terry Harper has always been somewhat of a drinking partner for him. To my understanding, the PPO had been dismissed at some point in time. I don't know. I was not his attorney in that hearing, but just in passing, it would do somewhat pay attention to other happenings in the court. I think that was before Judge Mertz and the PPO was dismissed. So when the prosecuting attorney is alluding to as a history of violating PPOs, that may or may not be true, but what I can say is that there have been PPOs that have been filed against him that have been later discharged for whatever reason. In any event, Your Honor, Mr. Goodman's just asking for some latitude, some leniency in terms of what it does ultimately. Clearly, you can't be out drinking and driving. clearly, you know, if you're causing a public danger, clearly you're a danger to yourself in many instances. But as long as I know Mr. Goodman, although he can be obstinate at various times, he is generally trying to be helpful. He did give some other defendants rides at certain points to court, not necessarily during this time period, but in other periods. He generally tries to be helpful towards his neighbors. If he didn't have this drinking problem, I don't think that he could find himself in the same position that he finds himself in today. The other thing that I would note is Mr. Ziegler had referenced that there was another drunk driving that was dismissed for whatever reason. I would ask the court not to take that into consideration as the matter was not resolved by a standard of probable cause because the matter was dismissed. And so even if you were somehow thinking about it, Your Honor, there's not even a preponderance of the evidence in as much as legally the matter was discharged in advance of the preliminary examination. And so there was no judicial determination that there was probable cause, let alone the higher standard of preponderance of the evidence to the extent that the court was considering it in the first place. Mr. Goodman really wants to put this behind him. Clearly, he may have some additional legal complications, but that's for another court to determine another day, and he does enjoy the presumption of innocence.
Thank you, Mr. Seeger. Mr. Goodman, was there anything you wanted to tell me before I impose sentence today?
Yeah, I'd like to know that, I know that on that PSI, I had my 9th felony. This is not my 9th felony, Your Honor. This is my 8th felony. It should make a whole lot of difference, you know, committing the crimes because I drink a lot, you know. So I'm asking if you let me do jail time, tether, probation, and send me to rehab as soon as possible. I'm gonna have to kill myself from drinking, you know what I mean?
Thank you, Mr. Goodman.
I drink a fifth a day, every day.
I certainly agree with you that rehab is something that you should be seeking out because you're right. You're going to kill yourself if you drink a fifth every day. You're going to kill yourself if you drink a fifth and then drive in our community, as you've done contrary to law on 3 occasions, back in 2018, back in 2021, and then in May of this year. You present as an individual who understands that you drink too much, but you don't present as an individual to me who has any real plan or desire to stop drinking. You use the words rehabilitation, and I get that. That's a step towards it. But your attorney used very important words that he understands. He was describing you. My client understands that he can't consume. He's a danger to himself in public. Those are very understanding words of recognition by your attorney. But I've had you in front of me multiple times. I've never heard those words of understanding from you. And the difference is stark to the court, whether or not your attorney recognizes the danger you put yourself in and whether or not you recognize it. And more importantly, whether or not after you recognize it, you take any actions to fix it. Up until this point, in your 55 years of age, you haven't appeared to have done anything. And while you complain that this is only your 8th felony to the court, and you followed it up, I think, correctly, whether or not it's your 8th or your 9th felony, number one, I'm sentencing you on your 9th felony because I haven't been convinced that the PSI is inaccurate. But even if it is inaccurate and this is your 8th felony, the fact remains that it doesn't appear to matter what court rules are, what court sentences are. This is at least your 8th and perhaps your 9th felony. You have 16 prior misdemeanors at 55 years of age. Enough is enough. That's from the court to a defendant. A defendant in that position should be able to self-identify and say, I'm sick and tired of being sick and tired. And it should come before you're standing in front of the court for an 8th or 9th felony and potentially looking at new felony charges from yesterday. I don't put any stock in those except to the extent that it's clear you're in jail. You're entitled to 1 more day of jail credit. And I don't put any stock in the fact that you were charged with another DUI. If I had more information attached to the PSI or otherwise to consider whether or not there was preponderance, then I absolutely could consider it, regardless of whether or not it was dismissed. But I don't have that information. What I do have is you at 55 years of age being sentenced on either your 8th or 9th felony with 14 to 29 guidelines range and with a clear apparent lack of ability to or willingness to control your actions. The fact that you served more prison than the last time than the minimum that I sentenced you to on the possession of a weapon suggests that you're also having difficulties in prison as well, or at least that they're not willing to allow you to be released at the earliest possible date. All of those things suggest to me that the most important part of this sentence is not rehabilitation. The most important part of this sentence is punishment. It's punishment and deterrence, that if you come to court with such unclean hands, with a long considered history of criminal violations, then you're likely to earn the maximum of the guidelines range. And the reason the guidelines range are so high is because of all of your priors and their relationship to you in terms of the timing. So I think those guidelines ranges are accurate, and I also think the top of the guidelines is appropriate for this offense and for you, the offender who committed it. So it is a court's order of sentence that you'll be sentenced to 29 months in the Michigan Department of Corrections. You do have a maximum period of 5 years in the state prison system. You do have 11 days of jail credit. State mandated minimum fines and costs will be ordered, which is a crime victim assessment of $130, court costs of $325, attorney's fees of $350, and a $68 state cost. Those fines, costs, and assessments are due today by state law. If you don't pay them within 56 days of today's date, a 20% late fee gets added on. You have the ability to ask the Board of Appeals for leave to appeal, and you can do that by filling out those appeal rights in their entirety. The top copy you just need to sign to indicate that you got the rights. Do you have any questions, Mr. Goodman?
No.
Mr. Seeger, anything further?
No, sir.
Mr. Ziegler, anything further?
No, Your Honor.
Your Honor, for the record, just returning a copy of the appellate rights. And where she needs a copy.
Hunt, you ready on Mr. Bielski?
Yes, Your Honor.